Thank you very much, Jules, and thank you for having me here today. Good afternoon to all of you. And just a few words about my background, in addition to what you said. While I was working at the EDPS, I worked at first for the supervision and enforcement unit, and then I switched to the policy and consultation unit. And in my last role there as a legal officer, I also participated to the Article 29 Working Party meetings, and especially to the international transfers subgroup. And I was, well, let's say, lucky, and not the opposite, to also be a part of the drafting team that drafted the opinion of the Article 29 Working Party on the Privacy Shield, and the core team that actually had to think about the effects of the Schrems judgment on the international data transfers between the EU and the US. So indeed, I recently moved to the US, and guess what found room in my luggage is the GDPR in the official journal. It looks a bit ruffled. Yeah, I saw that it was a good decision to make, making room for it. So what I'm going to talk to you about today is less known facts about the GDPR sanctions and legal disputes regime. I am not going to try to give you an overview of Chapter 8 of the GDPR. That would be impossible in 15 minutes. I mean, I would be in the World Book of Records for that one. But I will focus on some, well, less known facts and insights. As you've heard in some of the presentations before, and as I am sure you are all aware of, the GDPR is going to be directly applicable, a directly applicable legal act in the EU law. To be honest, this slide I inserted just during our first session today, when several questions raised about the bindingness and the direct applicability of the GDPR. After Professor Van Eyck said that indeed it may take more years before the member states would be fully ready to have the GDPR within their legal systems. And I made then a comment, and this is me nuancing it. You'll see Article 288 from the Treaty on the Functioning of the European Union that states that a regulation is binding in its entirety, and it is directly applicable in all member states. And the Court of Justice actually made it clear that this means that a regulation is technically just like a national law. So if it has sufficiently clear and precise norms, they can be invoked in court and directly applicable by national courts. Now, indeed, the legal environment of the EU is very complex, and it may be difficult, almost impossible, to find in practice a data protection authority or another supervisory authority of any sort that will issue a fine directly basing its decision on an EU regulation and not on a national law. But in theory, that is very much possible. That is very much possible, especially if we are in an area where we don't have a national law. So for instance, we have a member state that, let's say, took its time before translating the regulation into its national law, then an authority, or at least in my opinion, is perfectly entitled to apply the fine just on the basis of the EU regulation. And this is to reply to the discussion we had a bit earlier. Another point I would like to make is that Article 99, now the infamous Article 99, as you've heard Professor Van Eyck earlier, actually states quite clearly that the GDPR is applicable from 25 May 2018. So we have a clear date. It's not just the month of May. And then Article 99 also goes to copy what Article 288 from the treaty says about direct applicability. Now, the less known fact, number one, is that when establishing the fines under the GDPR, supervisory authorities will have to take into account, indeed, some criteria. So we'll have to make a proportionate decision. And you've already heard this idea earlier today in several interventions. There is actually a specific paragraph in the GDPR. It's under Article 83.2, from letters A to K, where you have these factors enumerated, and they are both aggravating and mitigating factors. I will just mention a couple of them. For instance, the number of the data subjects affected, the level of damage suffered by them, if the breach was intentional or negligent. And this is quite interesting in the context of the earlier intervention from our colleagues that talked about the German system, the degree of cooperation with the supervisory authority. If you remember that advice that you should go and establish a relationship, a trust relationship with the supervisory authority, that's very good advice, I can tell you that. And now the DPAs will have to take into account how well a controller cooperates with the supervisory authority in specific cases before deciding the level of the fine. It's also important how the breach of the law became known to the supervisory authority. That's also a criterion from the GDPR. So if a controller itself goes to the supervisory authority and comes clean, let's say, before the data subject goes there first, that will be an alleviating factor. Then adherence to approved codes of conduct will matter. Adherence to certification mechanisms will matter. But what's very interesting is that at letter K, you will see another factor is, well, any other aggravating or mitigating factor. That's very general, but that's not unusual in the EU system. So they indeed have to be flexible, and they have to proportionally look at things. What's interesting, and it will be interesting further on in the discussion, is to know that exactly specifically to that letter K, the European Data Protection Board, this new body created by the GDPR, right, will actually has a specific task to draw up guidelines for setting of administrative fines. So they will most probably have a role into detailing all those other mitigating or aggravating factors. Another fact I wanted to bring to your attention is that when you will read the GDPR, you will see almost everywhere in the liability and sanctions regime how it refers to the responsibility of the controller or processor. And you have all over Chapter 8, the controller or processor can be held liable, must pay for damages. In reality, the processor is only liable insofar it went outside the mandate with which the controller entrusted the processor. So that all other obligations set in the GDPR are set for the controllers. So the controllers are the ones that have to ensure you inform correctly the data subjects. The controllers are the ones that have to ensure data are erased if they receive a sound right to erasure request, for instance. So the processor is only liable if it acted outside this mandate. Now, what's interesting to see in the GDPR is that in Article 28, you have a very clear rule that states every time a controller gives away processing operations to processors, a contract or any other legal act, enforceable act, binding act, has to be put in place. And you have there a number of provisions, of clauses that need to be inserted in this contract. Another rule there is that actually the European Commission, talking about the role of the European Commission, can adopt standard contractual clauses for this type of contracts. And well, I state there that there are two situations where the processor is responsible, and it's indeed when it acts outside the mandate it was given. And also when it doesn't comply to obligations directly addressed to the processor. But if you look in the GDPR, you won't find that many obligations. There's basically one main obligation, and that is stick to what the controller told you to do. Now, this also means that if the processor starts to use the data entrusted to it for other purposes, then the processor becomes a controller, and then it's fully responsible under that new identity, let's say. Well, this is the most interesting less-known fact. And it says that one can challenge the European Data Protection Board's decisions directly to the Court of Justice of the EU. Actually, it's the General Court of the Court of Justice, to be more precise. And the procedure to be used, it's the procedure under Article 263 from the Treaty on the Functioning of the European Union. Now, why is that? And you will actually not find a specific provision in the regulation about this. This happens because the European Data Protection Board is created by the GDPR as a body of the European Union, a body or an institution of the EU. And then there is a general rule under the treaties that the acts of bodies of the Union can be challenged. They can be challenged by a number of active challengers from other institutions to member states. But Article 263 also has this paragraph 4 that states that any natural or legal person, so therefore data subjects or companies, may institute proceedings, so may go with an action for annulment against an act addressed to that person or which is of direct or individual concern to them. And this will obviously mean the decisions taken by the EDPB in the context of the consistency mechanism. Now, I'm not sure how well you are familiarized with what will the consistency mechanism look like, but just to make it very simple, let's say two data protection authorities don't agree on the outcome of a case where each of them is concerned to act, like the lead authority and another concerned authority, like, for instance, the authority of the member state where the challenger resides. That case goes to the European Data Protection Board, and then the European Data Protection Board gives a decision that is binding, that has legal effect. Well, that decision can be challenged directly before the General Court. Now, you may ask, what happens with other type of decisions the board will take? So what happens, for instance, with the guidelines I mentioned earlier about how to issue fines? Can those be challenged? The answer is we don't know yet, because the case law of the Court of Justice under Article 263 of the treaty is not that clear. And this happens because the Treaty of Lisbon in 2009 introduced this new concept that I highlighted in red there of a regulatory act. And you will not find in the treaty what a regulatory act is. The treaty doesn't talk about that. It just mentions regulatory act here in Article 263, and it says that this kind of regulatory acts which are of direct concern to natural legal person and which do not entail implementing measures can be challenged directly in front of the General Court by private parties.
So basically, an adequacy decision by the board might be challenged by an individual or maybe another regulatory authority directly to the Court of Justice.
Yes, but if the court, I mean, we don't know if the court will declare that admissible or not, because until now, I immediately, yeah. Yes. Yes.
Applied the first part of that provision, which is a direct or individual concern.
Mm-hmm. Standing, basically. It's standing doctrine, right?
Standing clause. And that might change, but so far it has been very restricted.
Exactly. The Court of Justice doesn't like to be bothered, with all this that may be hundreds of cases. However, this may change, indeed, as Biljana pointed out, because now we enter the realm of an entirely different set of challenges. And we will see this quite soon. I may say we're fortunate enough to see this before the GDPR enters into force because of this news that I just read last evening, that Digital Rights Ireland, you know, the famous Irish NGO, challenged the adequacy decision by the Commission, given by the Commission, for the Privacy Shield. They challenged it under Article 263(4) at the General Court. It's case T670/2016. It was published in September on the Curia website. So we'll have the chance to see how the court will interpret this regulatory act, which is of direct concern and which does not entail implementing measures.
But besides the sort of newsworthy information there that Privacy Shield now is also challenged in the Court of Justice, there is no novel legal theory in this case, right? I mean, the Commission was challenged in the Safe Harbor case and maybe in previous cases.
Well, yes, but the difference, and Biljana will talk a bit about that, is that the Commission was challenged before, but not, let's say, not directly the Commission, because another procedure was used, the preliminary ruling procedure in front of the Court of Justice. And in fact, you didn't have Max Schrems versus the Commission as a case, right? So it took much longer for the case to be actually brought in front of the court, and it had to go through the national court and through the filter of the national court, asking some questions to clarify the law, let's say. And then it was just up to the court. If in Schrems, the court could have very well said that they don't want to annul, let's say, the adequacy decision. But then they were proactive, and they said, well, we will annul it because this, and this. So in this sort of cases, the annulment itself, it's asked from the court, and it's very easy and direct to go to the court because you don't have to go through the national systems, and you just, you know, go directly to the general court and ask for the annulment. So this may lead to some very, very interesting cases. And this case is not only relevant, as I said, for the Privacy Shield now, but it's going to be very relevant for what happens after the GDPR takes full effect. Now, less known fact number 4, and we've talked a bit about this earlier, but in the GDPR, there's actually this Article 78 that is called Right to an Effective Judicial Remedy Against the Supervisory Authority. So you see that how we Europeans are very attached to the idea of rights and subjective rights. So while against the decisions of the EDPB, you have to go in front of the general court, and there's also a specific time limit. So you have to go there in 2 months after the decision is published, where we are talking about decisions of national supervisory authorities. They can be only challenged in front of the courts where that supervisory authority is established. So for instance, in a Spanish case, if you want to challenge the Spanish DPA, you go first in Spain, in the courts in Spain. All natural and legal persons can challenge the decisions that have legal effects. So any legally binding decision of a supervisory authority, and they cannot challenge, of course, opinions or guidelines from the supervisory authority. What's very interesting about this provision is that natural persons, but only natural persons, can also go to court to challenge the lack of action of a supervisory authority. This was not the case until now, at least not in most of the systems. For instance, Max Schrems had to wait for the Irish Data Protection Commissioner to issue that first, decision before he could go and challenge that decision in court. Well, under the GDPR, if 3 months pass in between supervisory authorities, after a supervisory authority receives a complaint, and if 3 months pass and the data subject doesn't hear from the supervisory authority anything, the data subject can go to court and challenge on substantive points of law for that specific complaint. That's also going to complicate things a bit. And now, because class actions were also mentioned several times today, I chose my last two less known facts related to class actions. What's going to be very interesting also after the GDPR fully enters into force is that the data subjects will now have the right to be represented by NGOs to initiate, well, class actions. You will not see the word class action in the GDPR, but you will see that the data subjects have the right to mandate NGOs to start trials or lodge complaints on their behalf, and this was not possible in all member states before this. And you will also see that NGOs have the right to do so on behalf of a data subject without a mandate from the data subject. Now, this doesn't sound that strange to American ears at all, but to my ears as a civil law lawyer, in a legal system, I'm Romanian, so our legal system is very, very similar to the French one. This sounds very strange. This will be a revolution to systems like mine, because it's right now, if you go to my country and you say, you'll have a trial on your behalf, but you won't even know about it, that's unheard of. And I mean, this is just an example, but there are.
We have a big case law body here, obviously, on how you become certified. That's like the whole trial sometimes, right? Do we know what legal process it'll be? I mean, 12 will show up and say, I'm representing the people, and how do we have any?
We don't have a lot of details. We don't have a lot of details in the GDPR, unfortunately. We just have some criteria about how the NGO must be in order to be able to come with this sort of complaints. And the criteria is that the NGO must be, legally established, must be in its state, it must have in its statute that it has public interest, and must be active in the field of data protection. So these are the criteria for the NGO, but we don't have any other details.
So is this another place where the national civil procedure will have to augment the GDPR?
Exactly. This is maybe the perfect example, because the national procedural law is so national, so typical to a legal system that this will produce some revolutions. And I really don't know the details about this, so maybe Felix can help us. But I know that in February this year, in Germany, the law changed, the procedural law changed. So when now the consumer protection law that allowed class actions in consumer law was extended to substantially cover some data protection substantive provisions, so that you can have class actions also for breaches of data protection, but that are somehow linked to consumer protection.
But as we know, some European countries don't even have the concept of a class action, which, like Jules says, bring up a lot of procedural issue, which really, determine the substantive merits of the case often. So, how do you see that working? Like, can you opt out? Are you bound legally by the results of a case?
You cannot opt out, that's for sure. What I can say, I mean, this is just a wild guess of, a EU legal geek, but you can perhaps argue that Article 80 is not sufficiently clear and precise, so you can use the criteria developed by the Court of Justice to give direct effect to norms, even to regulation, to norms from regulations. And you can say, look, this article is not sufficiently clear and precise, so it cannot be directly applicable in my legal system until we have national procedural laws. But this is something, I mean, you can argue this. I'm not sure if you will be successful. But this will raise a lot of issues. I would briefly like to mention here a pending case involving, again, Max Schrems, the famous Europe versus Facebook case. He is representing 20,000 Facebook users. In this case, started in Austrian courts. So it's a class action, but in Austria, you can only have class actions under consumer law. So the courts procedurally didn't really know how to deal with this. So then they sent a preliminary ruling question to the Court of Justice. And now we have another pending case from September started by Max Schrems as a class action. The question is exactly whether Max Schrems can be considered a consumer or not. So whether his class action can be admissible from the procedural point of view. So this is interesting for now, but after the GDPR enters into force, he will not have this barrier, let's say, anymore. I mean, you can start class actions only based on data protection law. And then if you have the Austrian law, which I am fully unaware of, so I can't tell you this now, but if you have the Austrian law that is sufficiently precise in the procedure to have class actions, combined with Article 80, then you may be successful in starting a class actions from 26 May 2018.